Welcome to the Am I Free to Go podcast, where the Constitution isn't just paper, it's ammo. I'm your host, Soundrone, with Soundbite News Media. Here on the podcast, we don't just talk about your rights. We lock, load, and defend them. We expose censorship, spotlight real amendment battles, and bring you the stories the mainstream's too scared to touch. So whether you're behind a mic, behind a badge, or behind enemy lines on social media, this is your front line in the fight for free speech. Strap in, speak up, and never ask permission, because around here, we know the truth. You are free to go. Episode 003, Time, Place, Manner. The First Amendment does protect free speech, but that doesn't mean anything goes. There are limits like time, place, and manner rules, and some speech, believe it or not, isn't protected at all, like threats or incitements. Courts across the country have backed the right to record public officials, as long as you're doing it reasonably and are not obstructing and within the law.
Welcome to the Deep Dive. We've got quite a pile of material here today. It covers everything from, basic legal rules and court cases to history and even really current stuff like recording police or what happens with free speech on social media. It's all focused on freedom of speech in the U.S. So our goal here, our mission for this deep dive, we want to take all these sources, sort of pull out the most important bits and give you a shortcut, basically, to understanding this really complex, but let's face it, vital topic, and why it actually matters day to day. Think of it as like decoding free speech. Okay, let's unpack this.
Yeah, it's a great topic because, well, free speech is incredibly protected here, strongly protected. But this is key. It's not absolute. It's not unlimited. The government can regulate speech sometimes under, certain conditions. And a really crucial starting point, I think, is remembering the First Amendment. It's primarily about restricting the government.
By government action.
Exactly. Federal, state, local governments, that happens through the 14th Amendment. It generally doesn't apply to private companies or, private individuals. Though, like you said, we'll see that line can get a little fuzzy sometimes. So when courts look at a government rule about speech, they hit this fork in the road almost immediately. Is the rule focused on what's being said, the content? Or is it about the how, the when, the where? And that leads straight to this fundamental distinction. Is the regulation content neutral or is it content-based?
Okay, so content neutral. These restrictions regulate speech without caring about the message or the viewpoint. They typically focus on what's called the time, place, and manner of the speech. The logistics, really.
Right. And we have a perfect example, I think, from the sources that makes this super clear. Like, imagine you're in a quiet suburban neighborhood, right? And the kid next door has a band, practicing loud, rattling the windows loud.
We've all been there.
If the town has a noise ordinance, say, banning loud noise after 10 p.m., that's content neutral. It doesn't matter one bit if they're playing rock or jazz or, polka.
The content doesn't matter. It's the volume and the time, the manner that's being regulated. That's it. Okay, so time, place, and manner TPM restrictions. That's how the government manages speech without, judging the message. But how do courts figure out if a specific TPM rule is actually constitutional? Is there a test?
Oh, yes. There's a pretty standard 4-part test, especially when we're talking about public forums, think parks, sidewalks, places like that. First, like we just said, it absolutely must be content neutral, no wiggle room there. Second, it has to be narrowly tailored to serve a significant government interest. Now, narrowly tailored is important. It doesn't mean it has to be the absolute least restrictive option possible. But it can't sweep up way more speech than is necessary to achieve the government's goal. It needs to be a decent fit. Third, it has to actually serve a significant government interest. And these are usually things we recognize as pretty legitimate government concerns. Right. Keeping traffic flowing, controlling excessive noise, public safety, preventing disruption of, say, government services, things like that.
Okay, significant interests. Makes sense.
And fourth, the rule must leave open ample alternative channels for communication. This one sometimes trips people up. Ample alternative doesn't mean the speaker gets their preferred spot or even the same method.
Like the speaking versus writing.
Exactly. Or even reaching the exact same audience. It just means there has to be some other reasonable way for the speaker to get their message across.
Okay, and that connects directly to this idea of public forums you mentioned. Because not all government property is treated the same for speech purposes, is it?
Not at all. That's a really critical layer. The type of forum heavily influences what kind of regulation is allowed. So you have traditional public forums. These are the places historically associated with free expression, streets, parks, public sidewalks. They get the strongest protection. Generally, only those content-neutral TPM restrictions we just talked about are permissible there. Then you have designated public forums. This is government property that isn't automatically open for speech, but the government has, chosen to open it up for that purpose. Maybe a university meeting room or part of a public building lobby sometimes. When it's open for speech, it's generally treated like a traditional public forum. That same TPM test applies.
Got it. Open means open under those rules.
Right. But then there are non-public forums. These are government properties that are not traditionally places for public debate and haven't been opened up for it. Think airport terminals once you're past security.
Yeah.
Internal government mail systems, military bases, and this comes up a lot, courtrooms.
Courtrooms, right.
Here, the government has significantly more control. Restrictions don't have to be content neutral.
Oh, interesting.
But, and this is crucial, they must be viewpoint neutral. And they have to be reasonable in light of the purpose of the forum. So, that example from the sources, no political signs in the courtroom. No. That's content-based, right? It targets political speech specifically. Right. But if it applies equally to all political viewpoints, no matter the party or issue, and it's seen as reasonable for maintaining order and decorum in a judicial setting, it might be allowed in that non-public forum. Viewpoint neutral is the key there.
Okay, wow. So digging into these forums and TPM rules, this brings us smack into something really current and, frankly, pretty contentious. The right to record government officials, specifically police. And the really tricky part, recording inside police station lobbies. Where does that fit?
Yeah, this is definitely a hot button issue. There's a growing consensus among federal courts, quite a few circuits actually, that there is a First Amendment right to record police officers while they're performing their duties in public places.
So, like on the street during a traffic stop?
Exactly, or at a protest. Several circuits, 9th, 7th, 1st, 10th, have cases affirming this. Yeah. Some states, like Colorado and New Hampshire, even have specific laws protecting this right and offering remedies if police interfere.
Okay, so public spaces seem clear. But what about inside the station, in the lobby?
That's where it gets murky. It's generally considered unsettled law. The sources mention a Pennsylvania case, Bradley. In Bradley, the court actually upheld a ban on recording inside a police lobby, and they used that same TPM test we discussed.
How do they justify it?
Well, the court pointed to significant government interests. Preventing the accidental disclosure of confidential information, protecting the identities of confidential informants or undercover officers who might be in the lobby, and also protecting the privacy of crime victims who might be there seeking help. And, the really striking part of that decision, the part that got a lot of attention, was the court suggesting that using parchment or quill.
Parchment or quill? Seriously?
Seriously. Writing things down outside the lobby was considered an ample alternative channel for communication. Mm-hmm. In the 21st century, that phrasing definitely raised some eyebrows.
Yeah, I'll say. And we're seeing this fight continue, right? With recent lawsuits like against the NYPD people challenging these lobby recording bans.
Yeah. Absolutely. Cases like those brought by Sean Paul Reyes and Patricia Rodney, they really highlight this core conflict. The public's interest in transparency and police accountability versus the department's arguments about operational security and privacy concerns within that specific lobby space, even though it's generally open to the public. Mm-hmm. It's a reminder, really, that even where a right like recording is recognized, it's almost never absolute. It's still subject to reasonable time, place, and manner limits. You can't interfere with police work or create a disturbance just because you're recording. Those TPM principles still apply. Okay, so we've talked a lot about content-neutral rules. Let's flip the coin now and look at content-based restrictions. Remember, these are the regulations that target speech specifically because of its message, its subject matter, or its viewpoint.
The ones that are about what you're saying.
Precisely. And the starting point here is very different. Content-based restrictions are presumptively unconstitutional. The assumption is they're not allowed. For the government to justify one, they have to overcome strict scrutiny.
And that sounds just right.
It is. It's the highest level of judicial review. The government has to prove that the law is necessary to achieve a compelling government interest, and that it's the most narrowly tailored way to achieve that interest.
Wow. So a really high bar to clear.
Extremely high. Very few laws survive strict scrutiny. It's designed to be tough for the government to win.
And this really goes back to that fundamental idea we mentioned, the marketplace of ideas, doesn't it? The whole concept that the government shouldn't be silencing ideas just because it doesn't like them?
Exactly right. That's the core principle. The government generally doesn't get to pick and choose which messages are acceptable in public debate. And the absolute most problematic type of content-based restriction is viewpoint discrimination. This isn't just regulating speech about a certain topic, like politics. It's banning speech because of the specific opinion being expressed on that topic.
So, like, allowing pro-government rallies but banning anti-government ones.
Perfect example. Or, say, on government property, allowing speakers against abortion rights but prohibiting speakers in favor of them. That's targeting a specific viewpoint. That faces the most exacting scrutiny, and it's almost always struck down by the courts.
Okay. There was a kind of helpful mental check mentioned in the sources from a case, Snyder v. Phelps, I think.
Yeah, that's a good way to think about it. Ask yourself, if someone delivered a different message, maybe even the opposite message, under the exact same circumstances, same time, same place, same volume, would they face the same restriction? If the answer is no, if the rule only kicks in because of the content or viewpoint of the message, then it's almost certainly content-based, potentially viewpoint discriminatory, and facing that very tough strict scrutiny standard. Now, even with all this strong protection for speech, it's important to understand, like most legal rights, it's not absolute. There are certain specific categories of speech that get less protection, or sometimes no First Amendment protection at all. These are areas where courts have basically decided that the harm caused by the speech outweighs its value in the marketplace of ideas, allowing the government more leeway to regulate it.
Okay, exceptions to the rule. What are some of the main ones we saw in the sources?
Well, a big one is speech that incites imminent lawless action. This replaced the older, vaguer, clear, and present danger test. Under the Brandenburg test, it has to be speech that is directed at inciting or producing imminent illegal acts, and it has to be likely to actually incite or produce that action.
So not just abstractly advocating violence someday, but...
Yeah, right. It's got to be immediate. The classic example is yelling, "Let's go burn down that building now," to an angry armed mob standing right in front of it. That's likely unprotected incitement.
Okay, what else?
True threats. These are serious expressions where the speaker means to communicate an intent to commit an act of unlawful violence against a particular person or group.
So not just like political hyperbole or saying, "I could kill you for that," when you're joking.
No, it has to be a credible threat that puts someone in fear. Like the example in the sources, "I'm going to kill you and your family tonight. I know where you live." Said in a way that sounds real. That crosses the line.
Thanks. Right.
Then there's obscenity. This has always been tricky to define, but the Supreme Court landed on the Miller test. It asks 3 things. 1, would the average person, applying contemporary community standards, find the work appeals to the prurient interest, basically, a shameful or morbid interest in sex? 2, does the work depict or describe sexual conduct, specifically defined by state law, in a patently offensive way? And 3, this is crucial, does the work, taken as a whole, lack serious literary, artistic, political, or scientific value? This last part is judged by a national standard, not local.
So it has to fail all 3 parts.
Yes. And it's worth adding, child pornography is treated separately. It's considered so harmful it's completely unprotected, period, whether or not it technically meets the Miller test for obscenity.
Got it. What about defamation? Lying about someone?
Right. Defamation, harming someone's reputation through false statements, can be regulated. But there's a huge distinction based on who the target is. For private individuals, the rules are generally easier. But for public officials or public figures, think politicians, celebrities, maybe prominent business leaders, like the examples in the sources, the standard is much, much higher. Thanks to the landmark case New York Times v. Sullivan, public figures have to prove actual malice.
Actual malice. What does that mean exactly?
It means they have to show the person making the statement knew it was false or acted with reckless disregard for whether it was true or not. Just being negligent or getting it wrong isn't enough.
Wow. Why such a high bar?
The idea is to protect robust public debate about public figures and issues, to avoid chilling criticism of people in power just because a mistake might be made.
Okay. And commercial speech. Ads.
Yeah, false or misleading commercial speech gets less protection too. That's why the government can regulate claims made in advertising, like financial product disclaimers or health claims by supplement companies like GNC needing backup. It's about consumer protection.
And the sources mentioned fighting words briefly.
Yeah, fighting words likely to provoke an immediate violent reaction from the person they're addressed to, are technically an unprotected category. But, as the material notes, it's very narrowly applied today. Convictions are rare, and it's almost never the right answer on, say, a law school exam question. It's largely faded in importance. But here's a really important overlay on all these unprotected categories, something called the RAV rule from another Supreme Court case. It says that even within these categories of unprotected speech, the government generally still can't regulate based on viewpoint.
Huh. How does that work?
Well, take obscenity. The government can ban all obscenity, assuming it meets the Miller test, but it couldn't pass a law banning only obscenity that promotes a specific political viewpoint while allowing obscenity with other viewpoints.
I see. So even if the speech type is unprotected, the regulation within that type still has to be neutral about the specific message or opinion.
Exactly. It prevents the government from using these exceptions as a backdoor way to engage in viewpoint discrimination. And there are a few other quick mentions in the sources of areas with less protection or more government control. Things like speech, that's, part of committing a crime itself. Certain torts like invasion of privacy or intentional infliction of emotional distress can be based on speech. Campaign finance laws regulate political spending, which the court has treated as a form of speech, but it's subject to specific rules. And government speech, when the government itself is speaking, it can control its own message. It doesn't have to host messages it disagrees with on, say, its official website.
Right.
And one more complex area is prior restraint. That's when the government tries to stop speech before it even happens, like getting an injunction to prevent a newspaper from publishing something.
That sounds serious.
It is. It's considered the most serious infringement on free speech and is almost always unconstitutional. The case Neer v. Minnesota established this strong presumption against prior restraints. There are incredibly narrow exceptions, maybe involving national security in wartime, but they're very rare. One place it does come up sometimes is in public schools, where administrators might have more power to censor school-sponsored publications, like in the Hazelwood case.
Okay, so we've got the big principles, the tests, the exceptions. How does this all play out in specific everyday contexts? Let's start with that huge one you mentioned earlier. Private actors versus the government.
Yeah, absolutely critical to keep hitting this point. The First Amendment fundamentally restricts government actions, federal, state, local. So your private employer, generally speaking, isn't bound by the First Amendment when they make rules about what you can say at work, or think about a private shopping mall owner.
Right. They can usually kick out protesters, can't they?
Usually, yes, under federal law. The Lloyd Court case said there's no First Amendment right to protest inside a private mall. Now, interestingly, some state constitutions might offer more protection. California's Pruneyard decision is the famous example, where the state court said the state constitution did protect speech activities in privately owned shopping centers accessible to the public.
So state law can sometimes grant more speech rights than the federal First Amendment.
Exactly. But the baseline federal rule is private property owner, private rules.
Which leads us directly to social media. Everyone talks about free speech on Facebook, Twitter, TikTok.
Yeah.
How does the First Amendment apply there?
Well, based on what we just said, it generally doesn't. Facebook, Twitter, all those platforms, they're private companies.
Not the government.
Not the government. So when they decide to ban a user or take down content or flag something as misinformation, that's typically their decision based on their terms of service. The First Amendment doesn't force them to host any particular speech. They have their own rules, their own content moderation policies. However, and here's where it gets really complicated and current. What happens when these platforms remove content or ban users because the government asked them to or pressured them to?
Ah, so the government is kind of acting through the private company.
That's the argument. Is that government involvement enough to turn the platform's action into state action, making the First Amendment apply? This is a huge legal fight right now. Federal courts are actually split on this issue, which strongly suggests it's headed for the Supreme Court sooner rather than later.
Wow.
And it really taps into broader public debates, too, like that Fire poll mentioned in the sources, showing many people are more worried about protecting speech online than stopping potentially deceptive AI content. It shows the tension.
Okay, what about people who actually work for the government? Public employees. Do they have free speech rights on the job?
They do, but they're significantly limited compared to private citizens. The key distinction courts make is, are they speaking as a private citizen on a matter of public concern, or are they speaking pursuant to their official job duties?
And that matters because...
Because if they're speaking as part of their job, say, writing an internal report recommending a policy change, the Supreme Court said in Garcetti v. Ceballos that the First Amendment generally does not protect that speech from employer discipline. The idea is the government needs control over its own operations and employee communications related to those operations.
But if they're speaking as a private citizen, off-duty, about something important,
then it might be protected. The courts use a balancing test, weighing the employee's interest in speaking against the government's interest in maintaining an efficient workplace. Cases like Lane v. Franks refine this a bit. It's complex.
Now, some states have laws about lawful off-duty conduct, right? Does that include speech?
Yes, that's another layer. Some states, like New York and Colorado, mentioned in the sources, have laws that generally prevent employers, even private ones, from firing people for lawful activities conducted outside of work hours. And lawful activities can sometimes include speech.
But there are exceptions.
Right. In those states, there are often exceptions if the off-duty conduct, including speech, creates a material conflict of interest with the employer's business or is directly related to their employment duties. California has a potentially broader law, Labor Code Section 96K and 98.6, that seems to restrict employers from firing employees for lawful off-duty conduct generally, which presumably includes speech.
So more protection in California, maybe.
Potentially, though importantly, the sources note this protection likely wouldn't extend to speech that's combined with illegal activity. So, for example, someone participating in the January 6th Capitol riots, even if they were exercising speech rights, the illegal conduct would likely remove any state law protection against being fired.
And this is still being interpreted by courts.
Yeah, especially how broadly the California law applies specifically to off-duty speech cases hasn't been fully fleshed out by the courts yet. It's an evolving area of state employment law.
Okay, one last big context.
Yeah.
Student speech. Public schools, universities, what are the rules there?
This is another area with its own set of rules. For K-12 public schools, the landmark case is Tinker v. Des Moines.
The black armbands case.
That's the one. Tinker famously said students don't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The standard is that student speech is protected unless school officials can reasonably forecast that it will cause a substantial disruption of school activities or invade the rights of others.
Substantial disruption.
Okay.
But later Supreme Court cases have chipped away at Tinker a bit, giving schools more authority in certain situations, like regulating lewd or vulgar speech, Frazier, speech in school-sponsored activities like newspapers, Hazelwood, or speech promoting illegal drug use, Morse. Though other lower court cases still uphold Tinker's core protection in different contexts. It's a balancing act.
And universities, are they different? Generally, yes. College campuses are often seen as quintessential public forums, especially outdoor areas where free speech rights are typically very strong, closer to the protections off campus. But even there, debates rage about speech codes, trigger warnings, speaker invitations, things like the Fire Chicago statement address these ongoing campus controversies.
Yeah, it seems like these free speech issues really pop up everywhere. The sources mentioned military blogs getting censored, FCC fines, battles involving groups like Scientology, even state laws related to boycotts like the anti-BDS laws.
Exactly, and things like the U.S. fluctuating in the World Press Freedom Index rankings. It's just another indicator that these are live, ongoing debates and pressures affecting free expression in many different ways.
Wow.
Yeah.
We've definitely covered a lot of ground here, from those core distinctions, content neutral, content based, and the tests courts use.
Strict scrutiny, TPM tests.
All the way to those categories of speech that get less protection, and then how it all applies or doesn't in specific places like police lobbies, online, at work, in schools. It's clearly not just one simple rule, is it? It's incredibly nuanced and seems like it's always changing.
It really is, and I think the key takeaway is understanding those basic principles, the strong protection, but also the limits. Knowing when and how the government can regulate speech is just as important as knowing when it can't. It really helps you, critically evaluate claims you hear about free speech being violated. Was it government action? Was it content-based? Was it maybe unprotected speech? It gives you the tools.
That's a great way to put it. Well, thanks for taking this deep dive with us today.
And thank you for tuning in.
Thanks for tuning into the Am I Free to Go podcast. Support the show by checking out our First Amendment gear, wear your rights proudly, and help us keep creating content like this. You can also join us on Patreon for access to uncut videos, outtakes, bloopers, and exclusive audio-only episodes. Don't forget to subscribe and hit the bell across all our channels. Links are in the description. And most importantly, we love reading your comments. Drop your ideas below, and you might hear your suggestion in a future episode.